Hello, everyone, and welcome to CBA's At the Bar, a podcast where young and youngish lawyers discuss legal news, events, topics, stories, and whatever else strikes our fancy. I'm your host, John Amarillo of Taft, Stettinius, and Hollister, and co-hosting the pod with me today is my friend Jack Sanker of Thompson, Brody, and Kaplan. Hi, Jack.
How's it going?
So, Jack, for those of our listeners who categorize themselves as fellow legal nerds, I think we've really got a doozy of a pod for them today. We're joined by Ajit Singh, Funding Director of the Law Finance Group, and Travis Lenkner of Burford Capital. Their company names probably give away what today's subject is. It's litigation financing and funding. And Jack, correct me if I'm wrong, but this is an area of the law that is really booming and rapidly changing the day-to-day practice of law. And yet, oddly enough, it's often overlooked by practicing lawyers and really even legal watchers.
Yeah, that's exactly right. And that's kind of what we wanted to discuss, specifically what litigation financing is, whether it's a good thing for lawyers and their clients, how it can be used by lawyers and their clients, and the potential impact that it can have on all of us.
Yeah, and I should probably add for our listeners that Ajit is joining us virtually from San Francisco, and Travis is joining us also virtually from New York. Welcome, Ajit and Travis. Thanks for coming to the pod today.
Pleasure.
Great. Thanks for
Thank you for having us.
So, Jack, before we get started, let's set the scene a little bit. In general, and for those in our audience who haven't dealt with litigation financing before, what is it generally? What are we talking about here?
So litigation financing, or litigation funding, it's sometimes called, is the practice where a third party that's unrelated to the lawsuit provides capital, usually, but not always, to the plaintiff in a lawsuit in return for a portion of any financial recovery from that lawsuit. So in return for equity in the outcome of the lawsuit.
Okay.
Now, the money from financing companies goes to paying attorney's fees, expert witness fees, court costs, a number of things. Now, it can also provide working capital for companies involved in expensive litigation or help business owners pay for personal expenses while they're working their way through a lawsuit. So it really spans the spectrum of potential uses for cash in a lawsuit on both sides of the bar.
Interesting. I have to admit that before we started researching for this episode, I really didn't have a firm understanding of just how versatile and widespread litigation financing is and how litigation is essentially becoming a booming new asset class. Ajit, Travis, maybe let's start with Ajit. If you would, why don't you take a moment and describe for our listeners, in your own words, what it is that you and your companies do in this sector?
Okay. Law Finance Group is a privately owned litigation financing company with offices in San Francisco and New York. We were founded by attorneys over 23 years ago, and we funded about over 1,000 law-related transactions in our history. Primarily, we provide non-recourse advances to attorneys or their clients for late-stage pre-judgment cases, settled cases, judgments on appeal, and other opportunities. And for law firms, we offer portfolio financing, whereby we advance a portion of the anticipated attorney's fees in a select group of cases. We have particular experience in appeal finance. That's how our company started 23 years ago, and that's we've done that throughout our long history. And my personal responsibilities at Law Finance Group is I was the funding director, legal counsel, just originating the transaction, educating the marketplace, and managing the transactional process for the client and counterparty, and throughout the whole process, and servicing the transaction as well. So,
Got it.
Keep it short.
Got it. Travis, would you describe Burford similarly?
Somewhat similarly, yes. So Burford Capital was launched in 2009. We're a publicly traded provider of litigation finance and legal finance solutions, traded on the London Stock Exchange, with more than $3 billion committed to the legal market overall. Our offices are in Chicago, where I am headquartered when I'm not joining podcasts virtually from New York. I'm sitting in the Chicago office, and also offices in New York, London, recently opened in Singapore. So operations around the world with a team of about 100 people. We focus on complex commercial litigation, business-to-business litigation, and we work with companies involved in that litigation, as well as with the law firms that serve them. And as you all described in explaining this sector and what it does, we provide capital in a lot of situations that look like litigation finance, but a lot of transaction structures that are more complex and more creative, but always with legal or regulatory claims or legal or regulatory risk as the underlying asset or issue or thing that we are underwriting in order to provide capital ultimately to our counterparty. And as you said, sometimes those dollars are being used to fund the litigation. Often they are not. And turning to Burford or LFG or others is simply a way to monetize an asset that otherwise is contingent and intangible, and really no other capital providers are willing to extend cash against those sorts of contingent legal claims.
That's interesting. I'm learning things even in the intro part of this podcast.
So when we were putting this together and doing a bit of research, we realized that litigation financing is a growing sector of the finance world. We have some data in front of us that shows that litigation financing has grown by over 400% in the last 5 years. And we see that demand for financing is coming from law firms of all shapes and sizes, as well as clients, businesses, and even Fortune 500 companies. So we'll give you a bit of a softball question here, but what are some of the reasons that lawyers, clients, law firms, companies are seeking financing? Why are they coming to you? What are they looking for?
Travis, why don't you lead off?
Yeah, sure, happy to. And I promise not to take the full podcast with the marketing. I'll leave some ground for Ajit to cover as well. I think we are providers of capital and also warehousers of risk for companies and law firms in connection with commercial and complex litigation, and also just the legal industry more broadly. So, what are they looking for? Sometimes someone who might approach us, a litigant, might approach us because they are looking for a solution to manage the ever-increasing cost of complex litigation. So they are looking for capital to fund the costs associated with litigation, to pay legal fees, to pay expert witnesses, discovery vendors, and the like.
And that's from both sides of the bar, right, Travis? Not just plaintiffs.
That's right. That's correct. That's correct. Other times, it might be a law firm or a litigant that approaches us. Ajit mentioned appeal financing, and that's something that we do and others in the space do as well, where someone approaches us. Let's say there's a district court judgment in hand, but now it's subject to Seventh Circuit risk. And I used to be able to say it's subject to the whims of Judge Posner, but I can't say that anymore.
Friend of the pod, Judge Posner.
Yeah, he's a friend of the pod. We had him on a couple of weeks ago.
And so, there are folks who are sitting on those judgments, both litigants and law firms on contingent or alternative fees, who might, for their own timing reasons or risk management reasons, want to convert some of that contingent position into actual cash so that they can offload some of the risk of how that case might actually turn out. All of these investment structures that we'll be talking about today are, generally speaking, non-recourse, meaning if we're making an investment based on the litigation outcome, and if that litigation outcome is unsuccessful or bad, we don't receive a recovery.
And that's how it's different. Sorry, Travis. I was just going to ask, that's how it's different than maybe more traditional funding sources for law firms, right? Because traditionally, if a firm didn't have the capital to fund, let's say a contingency case, they would go to a bank for the money, right? In which case they'd have to pay it back no matter what.
Right. So it's transformative in that way for law firms in particular, because firms that are looking to expand the amount of work that they are engaged for on a contingent fee basis, for example, can take money, obtain funding from a litigation finance provider to pay some of the costs of those cases, knowing that if they're unsuccessful, they haven't put the tax and the trust and estates partners at risk of having to pay back the bank because they drew on a line of credit in order to fund that work. So it dramatically changes the risk calculus for law firms in that way in particular.
So you guys touched on this a little bit, and maybe Ajit can talk about the underwriting process. How do companies like Burford Capital and Law Finance Group, which are not law firms, attach a certain risk assessment to very complex litigation, maybe in situations where even the attorneys that are involved in those cases really don't quite know how the case is going to turn out? That's got to be something that's unique to your field.
Yeah, it's a pretty extensive underwriting process. Both our companies have attorneys on staff. I know Travis is one, I'm one, but it's so you have to talk to the attorneys. You start looking what's publicly available, and it is an objective viewpoint on the case. And honestly, we I'm sure Burford is the same. We reject more cases than we accept,
Right.
because they're sometimes trying to transfer too much risk to us, and so we that's part of our assessment. And so we just do a detailed review of the factual disputes, legal issues, claims, and then make an assessment of the likely outcomes and timeline to resolution. And we also have outside counsel we work with, reviewing transactions as well for us independently. So with 2 reviews, it's a pretty extensive underwriting process. You also do underwrite the attorneys and potentially the venue, the judge's history, and you also even look at political external considerations.
Interesting. I wonder how it would feel to come to you guys with a possible case and then be rejected because you don't think it's good enough. I mean, that's kind of a...
that's always a tough thing.
Yeah, pick up the phone and start talking settlement with the other side.
Right, yeah.
Well, yeah.
Yeah, I mean, let me actually jump in there. I mean, first of all, interacting with us feels amazing. I'm not doing my job if I don't tell you that it does. But the serious point, in response to what you were saying, though, is just like Ajit said, I mean, we reject the vast majority of opportunities that we see. But I think even when we reject cases, which could be for a variety of reasons that are our own reasons that don't reflect on the merits of the case, we're not popping up out of a black box to just utter the word no and then disappear again. We're working with law firms and litigants to tell them why. And I think that is a helpful service to the people that we work with. And we might not fund a case this time. We might fund that case or a different case down the road, but we don't make it a mystery. And I'm sure Ajit and his team don't either, about why we aren't able at this point in time to extend capital. Mm-hmm. So I think, in terms of how it does feel to work through the diligence process, but ultimately not be successful if you're on the asking end and not the providing end of this relationship, I think at the very worst, you're getting insights into how a neutral third party, like, for example, a court, might view the claims that you're about to make, and you're about to make them potentially on a contingent fee or paying out of pocket to pay the lawyers. And either way, maybe you want to rethink how you're framing the case or thinking about the litigation based on your interaction with us. So I hope even when we turn people down, that we're doing so, constructively and not reflexively or without giving them at least the benefit of the experience.
Sure. So for those of our listeners who are attorneys who haven't worked with financing companies as sophisticated as yours, what kind of considerations might lead you to turning down a case other than just you think they won't win on the merits of a case?
I'm happy to speak, from our perspective. I think that Ajit laid out the list of a lot of the things that anyone in this space would think about. I like to tell people that the experience is a lot like if you were at a law firm and internally you were approaching your contingent fee committee for approval to take on a new matter. What would the people on that committee want to know?
Sure.
We want to know much the same things. I think one of the biggest reasons for us that can lead to a situation where we wouldn't be able to invest is where we think that because of the size of the case or some of the likely outcomes of the case, as Ajit said, someone's basically asking us to transfer too much of their risk to us, meaning they want too big of an investment relative to the size of the case. And it's an important thing for us to talk about is that we don't control the litigation in which we invest. And because of that, because we are passive capital, we have to make sure that we're setting up a situation where all of the people who do have control, the litigants and the lawyers, are incentivized to make decisions that we think are good decisions. So if we are investing too much in a case that's too small, and then a settlement offer is put on the table, the litigant, if acting rationally at that point, will reject it because she will want to go to trial and see if there's a grand slam possibility, because that's the only way that she gets a big return, because we've already basically provided too much in comparison to what the case is actually worth. So that's incentive structures and investment sizing is probably one of the biggest obstacles we run into when looking at cases on the front end.
Okay. Ajit, anything to add there?
No, I think Travis covered it pretty well. I think, obviously, one thing I'm sure, so both companies do pretty much every litigation financial does substantiate the defendant's ability to pay. That's obviously important for us to get repaid at the end of the day. But no, I think Travis covered it pretty well, and we're very similar in our approach.
One of the things, Ajit, that Travis raised that caught my attention. I mean, they all did, obviously, but one of the things that my ears perked up on was when he was talking about how law finance companies don't have control over a case, and that raised the whole issue of ethical concerns, which I think is a big barrier to entry for a lot of lawyers out there. They think back to their law school professional ethics class, and the word champerty jumps into their head, which is that century-old ban, and I think still exists in most states against third parties meddling in court cases by backing one of the parties. Can you speak to that a little bit? What that relationship's like? Can you make, if you can't have direct control, can you make suggestions? What's your involvement like?
Oh, we definitely do not have any control in the decision making of the process. And then most litigation financiers will put that in the contract, and transactional documents reflect it. So we want to obviously avoid any perception of champerty, maintenance, etc. So that's usually an expressly part of the agreement. So there are suggestions. Sometimes they'll come to us, discuss settlements, whether like just the economics of our deal, whether we should make a discount or just kind of facilitate settlement on our end. And sometimes they'll come to us on how to, because we've underwritten the case, they'll actually approach us and just ask us our input on the briefing or what our thoughts were, just like bouncing ideas off. But in no way it's a requirement. Obviously, after they go through a diligence process and they're comfortable with us and they realize we're approaching it objectively, and now we have an economic interest in this case. So most attorneys are receptive to feedback from third eyes on their case. So more input's always better, and so that's kind of how we approach it, and we offer that, but we don't require it.
And I'm sure all of this stuff is done with the explicit informed consent of the clients, obviously, right? It's not as long as though they're sharing things with you, without behind their client's back, so to speak. But as someone who has used some certain types of litigation financing myself in my own practice in the past, it does create somewhat of a balancing act where with the consent of your clients and everything else, you're balancing the interests of your client versus the outcomes that are going to affect the way that a third-party lending company may be invested in the case. So it does tend to complicate things.
Well, I think echoing what Travis said, that's why, we reject cases for a lot of the same reasons as the economics of the case potentially may cause conflicts down the road when there is a recovery. So we're conservative in how much we'll put into a case, and we hope to avoid those situations and avoid that. We don't want you to create a balancing act on your end, and so we try to avoid that, and that goes into our diligence underwriting process. But
I would just say, Jack, that the balancing act is far more pronounced in situations where lawyers themselves are directly working on a contingent fee basis.
Right.
And the attorney, we've lived in that world for many decades now, and the attorney ethics rules handle that just fine. So I think in situations where there is, client disclosure, the clients involved, the firms involved, the litigation funder has made an investment with one side or the other or both in terms of the litigant and the law firm. The best analogy that I have once the investment is made in terms of attorney ethics and just what the relationship looks like, you look like a jury consultant or a non-testifying expert or any number of the non-lawyers, even though we are lawyers by background, we're not lawyers who are engaged on the case. We look like the constellation of non-lawyers who get involved in big litigation these days and who get to have the benefit of work product protection and provide strategic insights. But of course, at the end of the day, the client is in control, and the attorney retains all of the ethical obligations that are present under the rules to be a zealous advocate, independent of outside influences. But litigation finance is far from the only thing that can be part of the attorney-client calculus that
oh sure
just makes it imperative on attorneys to be sure that they understand their kind of background ethics.
So it sounds like you're describing, I'm sorry about that, Travis. It sounds like you're describing it essentially as venture capital with a very light touch. Is that fair?
Sure, maybe that's fair. I mean, I guess I'll pick on the analogy only a little bit, which is to say any venture investor has reasons that they have conviction behind a new technology, a new management team, a new idea. Mm-hmm. The cost of capital, if you want to think of it that way, in venture capital, and the odds of success. Venture capital to the layperson sort of sounds like someone is implying, well, that you're taking a bunch of flyers, and if only one of them works out, you get a massive return, and that makes it all worth it.
Yeah, fair enough.
For a host of reasons, that's not what we're doing.
Right.
But in terms of what the relationship looks like, and then the degree of influence we have going forward on, if you're analogizing to the portfolio company of the venture capital firm, yes, that's about right. If the investor doesn't have control rights, which we never do, you can give suggestions, and the lawyer says, well, oh, what a great idea. I hadn't thought of that. Or, you have no idea what you're talking about. This has been a pleasant phone call, but I'm now going to go and litigate the case the way that I see fit.
Mm-hmm. That reminds me, kind of at the extreme ends of the spectrum in legal financing. Obviously before this pod, I did research on both of your companies, and I don't think you're anywhere near this or anywhere associated with what I would describe as activist investing, or what others have described as activist investing. Probably the most prominent example that may come to people's minds still is Peter Thiel's revenge plot against Gawker. But there's also another legal financing company that I was recently reading about where they are actually offering $100,000 to anyone who has a claim against Harvey Weinstein for sexual harassment.
Oh, wow.
In order to get their lawsuits off the ground. What do you think about that end of the spectrum in litigation financing?
Well, I hope they have a lot of capital, based on what I've read.
They're going to run out of money, it seems like.
I just think that's going to lead to that. I would say I don't think either one of our companies engage in that, and so it's just, you don't have a claim, then now you're coming forward with the claim. People are always going to look at that and be skeptical. It's like, oh, you're coming forward now because of the 100,000, et cetera. So I think that's it's a pretty extreme example. As with all industry, every industry, there's responsible funders and there's potential activities that are irresponsible. So I don't think I don't want to talk ill of the competition.
Sure.
Yeah, I guess I'm a little more. Bothers me a little less on its face. It's not something Burford has done, but those are.
Well, if someone has a legitimate claim and passes through your rigorous system of vetting and underwriting, from your perspective, what's the difference?
Right.
I think that's probably where I come at. It's a more newsworthy example. Maybe it's as much of a PR play as it is a sort of serious push for new cases in which to invest. But to your point, if 5 women who had not previously come forward have reasons that they need capital, or simply would take that capital in connection with bringing cases and put it toward the claims themselves, the only difference is that the prospective funder here, I think the firm Legalist, put out a press release saying they were doing this, as opposed to just trying to contact the women individually or waiting for the women to contact them. That difference, I think, is a little more aggressive, and so it puts maybe some of the issues that we were talking about in full relief, but I don't think that on its face it makes the underlying investments more troubling from an ethical perspective. But yeah, to be sure, it's a bit more in your face than either Ajit's firm or mine has traditionally been. There's no question about that.
But ultimately, you guys are investing in an outcome that's going to be decided by a judge or a jury, or it's going to be negotiated between a number of attorneys that are representing their clients. In a way, you are investing in, not to get on my soapbox, but investing in sort of justice and the justice system running its course. So it's not as though this is speculative investing, or it's investing for the sake of accomplishing something politically. Ultimately, the outcome and your value of your investment is going to be determined based on a series of laws and judicial system and everything else that we have in place.
For sure. And that, I have a lot more than 2, but I'll limit it to 2 pushbacks on the Peter Thiel comparison, because as you imagine, when you can combine sex tape and litigation finance. A lot of people have done that. And
I mean, we're trying to entertain our listeners here. So.
Sure. I mean, come on. You're jogging. People are doing whatever you're doing. You got to try to make this interesting. So I hear you. Look, I think you're right that we ultimately are involved for. We have investors to which we're accountable. Burford has public shareholders as well as private fund investors. So that makes us different from Peter Thiel. I guess, though, I would say, so I'll defend legalist, and maybe now I'll defend Peter Thiel as well. I mean, what he did is just a more personalized, one-on-one version of people funding public interest litigation, which also has been going on for decades, and it's one of the things that really drove the Champerty laws out of business, because we've decided that it's okay and it serves the public good for this club and the NAACP and other groups to
sure.
Oh, sure, the ACLU, yeah, this is something that's old.
Right. And so if Peter Thiel had just said, hey, it's not me, Peter Thiel, it's Committee of Concerned Citizens for Stronger Defamation Laws, whatever that acronym is.
He could have slapped together a 501c3 to do this and look a lot better from a PR perspective.
Correct, but like from a workings of justice standpoint, it's really no different at the end of the day, and I think a lot of people miss that.
So that point brings up... sorry, go ahead, Ajit.
Sorry. No, I guess, to echo what Travis says, and also to discuss Peter Thiel a little bit, because I've got a lot of publicity, is we have a duty to investors, and we don't... most funders will not finance cases to extract pain, kind of what Peter Thiel did. And so, but on the flip side, there are other parties out there who use money to kind of punish people economically. On the defense side, the product liability, med-mal cases, insurers won't lay down their swords, so to speak, until much later down the road after they've extracted some pain. So kind of it's similar to what
you don't say.
Just, we see it. Yeah.
So this conversation raises a kind of an interesting dichotomy that fascinates me about litigation financing. And there is, on the one hand, what Jack was talking about, which is that it seems like a great tool for access to justice, which is such a big problem today. It helps undercapitalized parties, law firms, companies pursue meritorious claims that they otherwise wouldn't be able to, just because the cost of litigation is so high. On the other end of the spectrum, you have some criticism that litigation financing actually just makes everything more expensive because there's more sunk monies in cases, larger judgments and settlements are required to satisfy all the parties. What do you guys think about that dichotomy?
So I think that you hear that criticism much more in connection with a somewhat separate industry and a space from the one in which Ajit and I are involved, namely consumer litigation funding, where individual consumer plaintiffs are able to obtain an advance of the value of a car accident settlement that they might have coming to them as a result of an insurance dispute, for example. And I guess I'll stick with the theme of defending legalists and Peter Thiel, and now consumer litigation finance. But I do think that there can be some predatory practices in that space. Those practices are bad. But the concerns that you hear about driving up settlement values, I frankly think that is more of the just sheer hackery of the special interest groups from the defense bar, who just want to, obviously, for their own reasons, pay as little as they can for claims, and force individual consumers into settlements much sooner, because those individuals might have really dire needs for cash. So as long as the rates being charged are commensurate with the risk and they're not opportunistic or anti-consumer, I think a lot of people would say, even in the consumer space, you're probably on the side of the angels if you're saying that consumers are getting higher settlements because insurance companies aren't able to settle, before the first pleading is even filed.
Sure. And Ajit, I read an article recently, I think it was in Law 360, that quoted one of your coworkers, Alan Zimmerman. And Alan was explaining that it's been, 5 years since the nearly $18 billion Deepwater Horizon oil spill settlement was struck, and the lawyers involved in that incredibly successful suit have yet to be paid in it. And litigation financing has proved to be a way for those plaintiffs to leverage the settlements and essentially take out loans on their expected earnings, rather those plaintiffs' lawyers, I should say. So going to Travis's point, this isn't something that can only be good for consumers, but it can be really be a boon for law firms as well, right?
Yeah, that's accurate. Plaintiff firms, a lot of them are contingency majority firms, so lumpy cash flow is their business model, and so we provide the capital, and there's a need there. So I think it can be very advantageous for law firms. It also they can expand their portfolio, expand their risk appetite, etc., by partnering with a litigation funder, which would give them additional access to capital beyond just the potential bank line, etc. So it's tough right now for law firms to get loans from banks, credit lines, etc., especially expansive ones. So we provide that need, and obviously the civil justice system is not getting any cheaper or any more efficient, and so we are a capitalistic response to those inefficiencies in the civil justice system, which affects attorneys and law firms, and so we believe we're a solution to these problems today. And so, it's law firms can survive day-to-day operations without having to worry about that by using lit financing.
Right, and not only survive, but I was also reading another article, I think it was in Bloomberg, where it was talking about a firm that it was a startup firm, essentially, a handful of big firm attorneys or exiles left to create their own firm, but they needed capital to do it, and they found that through litigation financing. They found a litigation finance firm to essentially capitalize their entire portfolio. So it's not just for existing firms, but it actually can be useful to start new firms, right?
Mm-hmm. That's correct. Yeah, so it's a way to just get off the ground. I read about that same firm, and it's interesting, and it's just a way to get off the ground and get moving. And obviously, capital makes this country go round. So to help to have access to it.
Yeah, and I think if you think about it from the law firm's perspective, what does a law firm have against as the assets? Like, what is a law firm's inventory? It's the accounts receivable from the work that it's doing.
Right? It's their cases,
particularly,
right?
Yeah, and particularly in contingency cases where that AR is contingent and tough to value, or if you have a lot of AR that is hourly, and you're an AmLaw 50 firm, but you want to expand your plaintiff side trade secret practice or your plaintiff side insurance coverage practice. As I said earlier, the folks in the tax practice group are perfectly happy with the annuity that they take home every year based on the hourly fees that are generated. But, the firm's looking around basically wanting to take more risk and needing to put more capital out the door to fund those cases. But it can only pledge what it can pledge, absent personal guarantees from the partner. So this is expansion capital, working capital, a way for firms to convert what they have into cash, either to increase their own year-end results or on the front end of the case to take on more cases and to be more aggressive than they would be able to be otherwise if they were simply self-funding.
Sure, and it seems like we read on a daily basis about the contraction of the legal market and the increasing problems that even the biggest of law firms are having with the billable rate model. So this certainly provides more versatility to law firms and more options. And I think that's probably a good place for us to take a break. We will be right back with Stranger Than Legal Fiction.
This episode of At the Bar brought to you by Amada Law Office Suites. You shouldn't have to practice big law to have an office space that wows. Meet in one of Amada's modern locations throughout the Chicago Loop, and your clients are sure to be impressed. Visit Amada's website, amatacenters.com, AMATA centers.com, or call 312-788-2700. This episode of At the Bar is brought to you by courtfiling.net, your solution for filing in over 100 courts in the state of Illinois. Courtfiling.net provides a better e-filing experience, focusing on speed and ease of use in the e-filing process while quickly addressing the pains that can arise from a newly mandated process. Courtfiling.net is affordable and offers 24/7 phone, email, and chat support. Visit us at courtfiling.net to take advantage to receive 30 days unlimited free electronic filings and see why it's the best solution for your firm. Let courtfiling.net worry about your e-filing so you can get back to taking care of your clients.
So before we wrap up today, we're going to play a little game our listeners are familiar with that we like to call Stranger Than Legal Fiction. The rules are simple. Jack and I both spent some time, stalking dark, dusty, abandoned law school libraries, or really just poking around Google for a little bit and state legislative websites to confirm what we were reading is true. And we found some of the strangest laws that are still on the books in the U.S. And we also just made another law up completely. Each of us is going to read one of those real but strange laws to our guests and to each other, read the fake one out loud, and we're going to quiz each other and our guests to see if we can guess which law is real and which isn't. Is everybody ready to play?
Let's do it. I hope one of them is Champerty.
That would have been appropriate, but you guys would know.
Right,
Ideally.
yeah, come on, we're talking to experts.
Wouldn't that
here.
be embarrassing if you got that wrong, though?
It's a fiction, right?
Yeah, right.
Correct.
Jack, why don't you lead us off?
All right, so 2 laws, one's real, one's fake. Option number 1. In Arkansas, a pinball machine cannot give more than 25 free games to a player who continues to win. So that's option 1. And option 2, in Illinois, it is a crime to possess more than 70 salamanders. More than 70 salamanders is a crime. So let's start with Travis.
I feel like I'm at such an advantage because I live in Illinois and have, as do you guys, obviously such a great sense of the salamander community.
Big time salamander lawyer, yeah.
Anyway, they're both very strange, but I think I'm gonna lean on just an old sort of conservative state gambling and anti-pinball aversion. If that
Sure.
is a thing that people had.
I think you're underestimating the big pinball market.
Big pinball,
Yeah, big
yeah.
pinball has a lot of lobbying
Right.
power.
And also, I'm clearly underestimating the anti-salamander lobby, but I think I'm going to go. I'm gonna say Arkansas is real and Illinois is not real.
Okay. Ajit, what do you think?
I go the opposite. I mean, the great salamander scare of 1842 in Illinois.
Everyone remembers
laws,
that.
But yeah, and that guy had 71 salamanders. I mean, he really.
They drew a hard line at 70.
Yeah, I think one of the stars on the Chicago flag is a reference to that salamander scare, isn't it? There's like the Great Fire, the World's Exposition, the salamander scare.
I never remember the fourth one.
Right. Salamanders, yeah.
All right, I think I'm going to go with Ajit on this one and say the Illinois law is real.
Okay. So, for the record, Travis is option 1, which is Arkansas. Ajit, option 2, which is the Illinois law, and the same with John. The correct answer here, the real law, is the Arkansas law. A pinball machine cannot give more than 25 free games to a player that continues to win. Interestingly enough, some restaurant gaming chains like Chuck E. Cheese actually are exempt from some of these statutes because they award games or toys or things like that, which don't constitute an exchange of, quote, valuable things. So there's an exemption in the Arkansas code there. And then in Illinois, as a caveat, that law is sort of an urban myth. For some reason, there's actually when I was looking this up, there was like a lot of people who were like, no, 70 salamanders is definitely legal. And I was like, I actually almost put that down as the real one, but fact checked it. CBA at the bar is not fake news. And it turns out in reality, it's illegal to keep any variety of aquatic life that's worth more than $600 if it was captured or killed in violation of the state's law. And where the 70 salamander figure comes from is roughly 70 salamanders at the market value per salamander adds up to about $600. So not quite.
Wow, good research job there.
I make sure that we're thorough here.
God, big pinball strikes again. Wow.
Some of that time you're never going to get back. You realize that. But I appreciate it.
You know what? It's going to come up in trivia one night, and I'm going to crush it.
Oh, you're going to rock it.
Yeah.
You're going to be the hero of the bar.
Yeah.
It's time to shine. Yeah, it's time to shine.
All right, round 2. In Nebraska, drivers on mountain highways are required to stay as close to the right-hand edge of the road as possible. Or option 2, in Oklahoma, it's illegal to lasso an ostrich, violation of which law can result in a $1,000 fine and up to a year in jail. Ajit, why don't you start us off?
I'm going to, I think you said it's in mountains in Nebraska, I don't think is real. So I would say the lassoing the ostriches, it sounds fun, so they probably outlawed it. So I'd go with that one being real.
Travis, what do you think?
And, so I grew up in Kansas. Again, I feel like I have an unfair advantage because I'm so deep in the lizard scene locally, and now I'm from the state between the two states you just picked. But I don't know, staying on the right-hand side of the road. I grew up on a farm, dirt roads. You want to do that even if you're in the hills, but I'm not sure about the mountains. Maybe the sand hills of Nebraska, but not the mountains of Nebraska.
Mm-hmm.
And like Ajit, I think I totally believe that someone from Oklahoma might have tried to rope an ostrich. So I have to go with B. I'm
Jack?
going to say the ostrich is real.
The ostrich is real. All right. Jack, what do you think?
I guess, are there ostrich in Oklahoma? I didn't know. I thought they were, maybe.
Haven't you ever had an ostrich burger?
I suppose, but I
They're
thought
good.
it was from Madagascar or something. I have no idea where ostriches are from.
It's a grazing animal.
I guess. I'm going to go with option 1, driving on the right-hand side of a mountain in Nebraska, but I have doubts as to whether there are mountains in Nebraska as well. But I'm going to pick option 1.
And you would actually be right. And to the point Ajit was making, that is the great irony of the law, because there are no mountains in Nebraska. The doing my due diligence, the highest point is Panorama Point, which stands at 5,429 feet above sea level, but it's considered merely a low rise on the high plain. So it's just, I really like to find out the story behind this law. I couldn't find anything on it, but I'm sure it'd be a good story.
Someone just overreacted to the panorama, it sounds like.
Yeah. Did you come up with the ostrich bit yourself?
Yep, that was all me.
Wow. Okay. I like it because it's compelling.
Thank you.
You want to protect their necks because they're so long.
That's what I was thinking. I mean, they're so fragile, right?
They should ban that, though. I'm firmly on this new law, Johns.
Yeah, maybe we have to make that the law here in Illinois. We'll start a letter writing campaign. And on that flattering note, that's going to be our show for today. I want to thank our guests, Ajit Singh of the Law Finance Group and Travis Lenkner of Burford Capital, for joining us here today and giving us valuable insight into this increasingly important sector of the legal industry. It was both fun and informative. I also want to thank everyone here at the CBA who makes this machine run, including my co-host today, Jack Sanker, our executive producer, Jennifer Byrne, and our sound crew, Ricardo Islas and Steve Wyrick. Remember, you can follow us and send us comments, questions, episode ideas, or just troll us on Facebook, Instagram, and Twitter at CBA at the bar, all one word. Please rate us and leave us your feedback on iTunes, Apple Podcasts, Google Play, or wherever you download the podcast. It helps us get the word out. Until next time, for everyone here at the CBA, thank you for joining us, and we'll see you soon at the bar.